Hi, I'm Doug Shapiro, and I'm been asked to talk about the rights of injured folks and the rights of insurance policyholders, and I'm done. There are no rights. Mary Ellen talked about the doors being closed to citizens who are trying to preserve the environment, and there was discussion about the doors of the court being closed to consumers, but there is one group in this state to whom the doors of the courts have been flung wide open, and that is the insurance industry. And the Michigan Supreme Court has sent a message loud and clear. Bring us your wish list, and bring us what you were embarrassed to put on your wish list, and we will give it to you. And I have literally had defense lawyers say to me, I am embarrassed to make this argument, but I got to make it because I can win it. And that's the reality of what is going on out there these days. Let me talk briefly. Everything I'm going to try and do briefly, and nothing is I'm going to cover very thoroughly. First, I want to talk about PIP insurance, no-fault insurance, which has radically changed. Most of you are probably aware of the 1973 legislation that had set up this fantastic system whereby people would not have to litigate their right to get their medical bills paid or their first 3 years of wage loss paid if they got hurt in a car accident. We wouldn't have to fight about who was at fault. You just get it paid. There was a statute that would say which insurance company had to pay, whether it was yours, the other drivers, or somebody in your home, and the rates would be set so everybody would be protected, the lawyers would be out of it, and you'd get your medical bills taken care of. The area of no-fault insurance has radically been transformed in the last 8 years. By my reading, and I confess I'm prejudiced and I may be wrong, I could not find a single Michigan Supreme Court case between a no-fault insurer and a no-fault insurance company in which the insurance company did not prevail. Not a one. More broadly, the Supreme Court has spoken in such broad language as to eliminate the most fundamental safeguards against insurance company abuse. Under the law, which has existed probably as long as insurance companies have existed in modern society in this country, insurance companies were held to have what's called a fiduciary duty to their policyholders. It means they can't just do what's good for the insurance company. It means they have to do what's good for their insured, their policyholder, like a lawyer has to do what's right for their client, like an executor has to do what's right for the estate and not just lie in his or her own pocket. That was the fundamental rule that governed the insurer-insured relationship. In what can only be called Orwellian, the Michigan Supreme Court, in the last couple of years, redefined the nature of the fiduciary duty, and here's what they had to say. In order to make sure that the insurance company is there for its insureds, the insurance company has to have a big pot of money. Otherwise, they won't be able to pay claims. And the best way to assure that they have that big pot of money is to deny claims. Therefore, the fiduciary duty requires that claims be denied. I mean, this is the level of infantile or Orwellian logic that it's come to. And that's an approach that's going to be applied across the board more and more, I think, as we look at issues of fiduciary duty between the powerful and the powerless from this court. Now, the fiduciary duty was enforced by several mechanisms of contract or policy interpretation. The Supreme Court, well, let me just say generally, and we've all been taught that in law school, insurance policies are not what are called arm's length contracts. People don't have their lawyers meet and work out a deal and everybody shakes hands, we have an understanding as to what the compromises are, and we have what they call a meeting of the minds. An insurance policy is a product. It is written by a lawyer and insurance company experts for one side, and it is a form and it is brought in, and somebody signs a piece of paper and says, I bought this and here's the money. They may never get a copy, and if they get the copy, it's never read. Now, and if it's read, it's surely not understood. But in any event, the courts have always recognized that and say, we're going to apply certain rules to this interpretation. One, we're going to apply a rule called unconscionability. If the contract, the policy is so outrageous as to just be unacceptable, we're not going to enforce it. We're going to protect the policyholder. Second, if there's an honest dispute about what policy language means, and if any of you have ever read an insurance policy, there can be an honest dispute about everything in an insurance policy. I mean, I read them for a living, and I don't know what they mean half the time. But in any event, if there's an honest dispute, we're going to interpret it to favor the person who didn't write it, because the person who wrote it had the opportunity to make it as favorable to them as they could. Well, and another rule that says the reasonable expectations of the insured will be protected. The Supreme Court majority, which has been tactfully called the majority of 4 here today, has explicitly eliminated these doctrines. Shamelessly said, we will not protect the right of the insured whatsoever. We do not care what is written. Whatever is written by the insurance company and however the insurance company interprets it, we stand here to enforce it, period, end of discussion. I want to talk about a couple of no-fault cases in particular so that you can see how this manifests in real people's lives. The time to bring a claim under the no-fault statute is 1 year. And it's always been understood that in terms of how far back, you're allowed 1 year back. It's called a 1 year back rule. It means that if I sue today, I can seek benefits 1 year back from the day I sue. So it was always understood that the time that you had to file the suit ran from the date that the denial was issued by the insurance company. In a case called de Villers, which I think was 2003, I'm not sure, the Supreme Court said, no, it doesn't run from the date that the denial is issued. Your 1 year to file suit runs from the date you make the claim. Now, most people, particularly in a society, where if you file a lawsuit, you're a bad guy, don't think of suing their insurance company before they even get a denial. So as the insurance company engages in what they pretend is good faith negotiations, and the year drags out, and the person finally says, gee whiz, I'm going to go to a lawyer, it's too late. So it used to be the settled law since 1973 when the No-Fault Act was adopted. Your year ran from the denial, so you had a real effective period of time to bring a case. Now it runs from the date you bring the claim. A whole class of claims is simply wiped out, and the money is saved for the insurance company. In a subsequent case in Cameron, the court, again, forgive my rhetoric, but in what really Ebenezer Scrooge would have, stood up and applauded for this before his revelation, said that the tolling statute for children and brain-injured people that protects them from having the statute of limitations run out because they cannot understand their legal rights does not apply in no-fault cases. After 1 year, they are done. 7-year-olds, 2-year-olds, brain-injured people. Never was the case before, and the tolling statute existed long before the no-fault statute existed. Other cases simply limit the types of claim, whole sections of areas of claims that are simply eliminated. In a case called Proudfoot, which I think on its face is appealing in a certain way because it says you can't sue for insurance benefits until you incur the cost. In other words, until you go to the doctor and that doctor says, you owe me $150, you can't ask the insurance company to pay the $150. I mean, there is something appealing about that. But I work with these people in reality, and this is what happens. The insurance company says, we're not making any commitment to you whether or not we're going to pay. We don't have to. Send us the bill. Then that person goes to the doctor. The doctor says, who's your insurance company? They say, that's in my insurance company, and the doctor's office calls. This is real. And the insurance company says, we're not promising to pay this bill. And the doctor says to the person, well, you can't come to my office unless you pay. So what that means is if you have the resources to pay for your own doctor bills, you can get reimbursed by no fault. But if you don't have the money out of pocket, no doctor will see you. And the court has sanctioned that and said poor people lose their right to no fault benefits.